It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my mega superstar co-host, Brett.
Hello, Alice. It's such an honor to join you. I'm glad that at least in your eyes, I am a superstar.
Well, you are a superstar because I've just decided if you can't be a superstar, you might as well just buy the gear of superstars. So Brett got us these amazing, he got them directly from Taylor Swift. It's her microphones because I apparently don't know how to speak properly into my microphone. And by having Taylor Swift's microphones, I think by transitive property, we are mega superstars.
I think that's the way it works. If you just buy the right equipment.
It's the rule of stardom.
Yes. Fake it till you make it. And we're definitely faking it.
I don't know about you, but I have an awesome setup right here.
Well, we're going to see what it sounds like when we finish.
You want to know something funny? I know, we need to hear this out. So I'm still in my closet recording, and the light right above my podcasting desk in my closet office, contraction, has gone out. And so I'm like sitting in the dark in my closet.
I wish we were doing this by video.
No, it's best that we don't. But having had it be broken, no, guys, it's not just switching out the light bulb. Something's wrong with the actual socket. I finally called an electrician, and he was like, "What's going on in here? Like, what's all this gear you have?" I was like, "Not everyone has a cloffice? Clearly, this is my podcasting studio." And he's like, "Okay, lady." He left real quickly.
Yeah.
I hope he comes back to fix my light.
Not everybody has a cloffice, but everybody has a podcast. So
Exactly. And I'm sure that's what he was thinking. Like, he was like, this darn new generation thinking they can make it rich being podcasters, because he's probably like 5 years older than me, but that's how I think he's thinking about me.
It probably is.
Oh my goodness. Well, this is just a fantastic ramp up, because there's so much to talk about nothing. And this is my favorite kind of episode because there were all these articles. You know, I'm up all hours of the night nursing my baby who doesn't like to sleep, and that's okay. But really, I'm up like at 1, 2, 3, 4, 5, 6 a.m. And what do? I go look at the news because, you know, I've already like exhausted all of my social media. You guys need to post more. And I saw all these articles about the case that has gripped the nation, the Idaho murders. And I was like, my goodness, with all these headlines, there must be something really substantive going on. And in fact, there's nothing substantive going on, Brett, even though the news really is spinning it up as like, I don't know, the end of the prosecution or the end of the defense or whatever you want to say.
I feel like we could just do all our episodes on fake news coming out of the Brian Kohberger case. Like, it seems like there's just so much of it. And I've come to realize, watching how this stuff develops on Twitter, there are just certain people who have figured out the perfect recipe for generating a lot of traffic, and they watch the docket, and things get filed on criminal dockets all the time. I mean, by the time a case is done, there are hundreds of filings on a criminal docket. The vast majority of them are standard practice, or not really that important. But if A, you're not a lawyer, and so you're not familiar with sort of the technicalities of things, and B, you're really invested in a case, you can make anything seem like it's a huge deal. And that's what we've seen. Recently, there were a couple filings that we want to talk about. One was the prosecution team added a couple attorneys from the state AG's office, and the other was a subpoena from the defense to one of the surviving roommates and a motion to quash filed by her, and that one's gotten most of the attention. So let's address the first one very quickly. When these two attorneys were added from the AG's office, of course, there were people whose response was, this is a sign that the whole prosecution's falling apart. They know what they're doing. They need lawyers. What's going on? And it's like, this is a huge case. I mean, it's just this is typical, frankly.
It's
in any case you have like this.
It's literally nothing, right? Like, I'm sorry to cut you off, Brett, but it's one of those things that you see, you're like, wow, it must have been a slow news cycle day, because we've both worked in various offices, and no matter what office you work in, private or public sector, resources are always slim, especially when it comes to a trial of this magnitude. And you guys have watched big trials on TV, and you saw the Murdaugh trial, and you saw how many attorneys there were. It takes a lot of attorneys to go through all of the evidence, to just literally have enough bodies to take all the witnesses, to file all the little briefs you have. By little, I mean, like, sometimes you'll have dozens of motions in limine. And in another Legal Briefs episode, we've explained that those are, pre-trial motions, but there can be just so many filings that you have to do that it would suck up all the time of the lead attorney if they had to deal with all the intricacies of a case of this size.
And the other thing, when you have a case that you think is going to go to trial, and maybe this is one that we think is going to go to trial, I don't know. It's a little early yet, but obviously the defense they're not just laying down. They're putting up a defense to this point. We'll see what they end up doing. Taking witnesses is really hard, and it's tiring. And the best way to do it is to stagger your attorneys so that you have one attorney who takes a witness, then a different attorney takes a witness, then another attorney. The Murdaugh case that Alice just brought up is the perfect example of this. If you watched it, you saw that. They had a large team of lawyers. It wasn't all Clayton Waters taking witnesses. There were multiple attorneys who were doing it. And in fact, if you had been following the Murdaugh trial, we could have done this same episode on it, because at least two of the lawyers who ended up on that team were added pretty late. They came in onto the team pretty late. You had Clayton Waters, who's sort of the main guy, but then a couple of the other ones, including the guy who did the rebuttal closing, was a late addition to the trial team, and it was for the same reason. This is going to be a big case with a lot of witnesses. We need really good lawyers, and we need more of them. So they added some, and that's all it is. And it's a smart thing to do. It shows, once again, that in this case, in particular, these folks are happy to accept help. And they've done that from the very beginning. It's exactly what you want to see. You want to see them doing the right thing and preparing accordingly for this case. And I think that's exactly what you're seeing from them. So I see that as just another indication that they know what they're doing, and they're going to approach this with the kind of seriousness and, in some ways, humility that they need to.
And that's a great point, Brett, that you raised, that taking witnesses takes a lot of time. So, in a trial that Brett and I had where there were over 100 witnesses, we did just that. We quite literally divided the number of witnesses by the number of attorneys and divvied them up. We tried to have some system, but it was basically like we get a fraction of the witnesses. And there were days in court where if a certain witness went over and we had like a smaller witness that didn't take a lot of prep, if one of us was just exhausted after a very long direct or a very long cross, we would look to the other and say, hey, can you take this like pretty simple witness just to give me a break to sit down, take a sip of water, collect my thoughts so that maybe sneak a protein bar before I have to stand up for another marathon of a witness. We did that all the time for each other. We were tagging out. You would see your co-counsel getting exhausted and you might tap them and be like, hey, let me take this next one. Those are not for the big witnesses, but those are for the small ones. And remember, in order to get those witnesses on the stand, there is all the prep work beforehand. So for every probably one witness you put on the stand, you're going to interview factors more than that. And someone has to be sitting in on those interviews, making that legal determination. Does it make sense to put this person on the stand instead of the other person? And that literally just takes up time as you sit in an interview room and hear witness after witness after witness tell their story. And in your mind, you're having to keep it straight and kind of draw that big strategy map of trial and think how it all fits together. And again, when you're sitting in a witness room, you're not doing anything else. You're not writing briefs. You're not looking through the evidence. You're not making phone calls that you have to. You're not doing anything else. And so talking to witnesses is not just the literal standing up in court and taking someone's testimony or cross-examining them. There's all the prep work that comes before it, prepping the actual witness who takes the stand and backing up even further than that, being the one who writes the outline to prep the witness who's on the stand, and backing up even further than that, being the one to sit through many other witnesses who never make it to the stand to determine who the best witnesses are. And the only way you can attack that kind of a problem is more manpower. And you add people as they become available as well. You would add people before something substantive like what we're about to have, a preliminary hearing. It doesn't make sense to tie up a bunch of lawyers' times when all you have is a bunch of discovery, but not a lot of action. Those attorneys need to be dealing with the docket elsewhere. And let's say they come off of a big case and then the Idaho case is heating up. Those attorneys that now have bandwidth will come and join this team. So this is a very fluid thing. Probably most of that office knows about the case to some degree. They probably talk about it. They're probably helping strategize. They're jumping in when another attorney can't do something on the case. And so this is not foreign to any really prosecutor's office.
And I just want to echo something Alice said. There are a lot of cases, particularly, if you're in a DEA's office, you might have a trial day where you have 30 trials set, 29 of them will plead. You're never sure which one will. You got a big stack of files. And if you go to trial on that day, you're basically just doing it by the seat of your pants. You grab the file, you find the officer, you put them on the stand, and you examine them on the fly. That happens a lot. That's not what's going to happen in this case. In big cases like this, big murder cases, there's a ton of prep work that goes into it. And I think some people think that, like in the Murdaugh case, those guys just walked in there, called a witness, and then just sort of stood up there and asked them questions. And then when they'd asked all the questions they wanted to ask, they let them go. That's not what happens. They're drafting outlines, they're preparing questions, lines of questions, directions they want to go, what they want to get out, which exhibits they want to get in, how they want to get them in. And there's just so much work that goes into it. I don't know if this case will go to trial or not, but it's really smart to go ahead and prepare as if it is going to. And if it does, it's going to be kind of like the Murdaugh case. It's going to be long. It's going to be involved. There's going to be a lot of witnesses and a lot of prep. So I'm glad that they're doing that. And as Alice said, it's not just the trial. We have the preliminary hearing that's coming up. This is a probable cause hearing. As most of you know, in Idaho and in a lot of cases, a lot of states, you can be arrested on a complaint. And the way the complaint works is an officer swears out a probable cause affidavit. In an earlier episode of this very podcast, we went through the probable cause affidavit in this case, swears it out, magistrate judge reads it, decides whether or not there's probable cause. If there is, issues an arrest warrant, and you go and arrest the person. But in this country, we don't just take officers' word for it. It's enough to get arrested. But at some point, you're able to challenge that probable cause. And there's two ways the prosecutors can deal with that in the states. In the federal system, you have to go to grand jury. It's a constitutional right to a grand jury. That does not apply to the states. So in the states, if they don't want to do grand jury, they can have a hearing in front of a judge where evidence is put on. It's sort of a semi-adversarial process. Evidence is put on, witnesses are called, they can be cross-examined, and at the end of it, the judge decides whether or not there is probable cause that a crime was committed and that it was committed by the person who's been arrested. So far in the Idaho case, they have not chosen to go to grand jury. My understanding is they don't do a lot of grand jury in Idaho. They still could do that. But as of now, the anticipation is that in a couple months, there will be a preliminary hearing at which point the prosecution will put on at least some of its evidence to show there's probable cause to believe that Bryan Kohberger is the murderer of the 4 individuals in the Idaho murder case. How is that going to go down? Let's talk about the law in Idaho, and let's talk about this issue that's recently arisen. So first of all, the law. Idaho Criminal Rule 5.1 governs preliminary hearings, probable cause findings. And Section A of that provision says, preliminary hearing. Unless indicted by a grand jury, a defendant charged in a complaint with any felony is entitled to a preliminary hearing. So if you're indicted via a grand jury, we're going to trial. There's not going to be any hearing. You're not going to be able to challenge probable cause. If that doesn't happen, you're going to have this preliminary hearing. And at that preliminary hearing, there will be a probable cause finding. And Section B of this provision reads, probable cause finding, if the magistrate finds that a public offense has been committed and that there is a probable or sufficient cause to believe that the defendant committed the offense, the magistrate must immediately require the defendant to answer in the district court. So basically, if you find probable cause, then we're going to district court. We're going to move forward. We're going to move towards trial. In one of these hearings, the defendant is entitled to cross-examine witnesses produced against the defendant at the hearing and may introduce evidence in the defendant's on behalf. And if at the conclusion of that hearing there is not a finding of probable cause, at that point the magistrate judge can dismiss the complaint against the defendant and the defendant is free to go. Obviously, that happens very rarely. Very rarely would that happen, but it is a possible outcome and the reason you have the preliminary hearing in the first place.
So note that these two procedures are just aiming to get at the same outcome. The outcome is that the prosecution has met probable cause, the standard of probable cause, whether it's by a grand jury, so jury of your peers, that's non-adversarial in the sense that only the prosecution presents to, or before one individual, the magistrate judge, where the defense does get to represent. So you kind of see the give and take. You know, the defense doesn't get to put on evidence in front of grand jury, but it's also not up to just one person voting. It's up to, an entire grand jury to vote for probable cause. Or flip side, you have just one judge who is learned in the law rather than just your commoner off the street who's been summoned to serve on grand jury, who makes a finding but has the benefit of hearing from the defense, all to get at the same outcome. Now, preliminary hearings are a bit of a mini trial because of what Brett just told us. The defense gets to cross-examine, they get to present evidence on their client's behalf. Now, the advantage to the defense is that they get a taste of what the prosecution is going to argue because the prosecution essentially puts on their case and it locks in the statements of witnesses. We've talked about this before where you have to be selective in who you put on the stand before trial because any sworn statement is just a potential for impeachment later. It's really hard to say the same thing twice, 3 times, 4 times, and any sort of inconsistency may be absolutely innocuous, right? You just forgot. But you can see how the other side can make hay of any inconsistencies in one witness's sworn testimony. And if the witness does change their mind later, they've already said something previously if they took the stand. And that can just, that could be a disadvantage or an advantage depending what side you're on. Now, if the witness changes their story at trial and varies from what they said in the preliminary hearing, the defense can use that statement to undermine their credibility. We've talked about this a lot, and you can see why that would be the case. You're like, well, Miss Smith, earlier at the preliminary hearing, you said you saw a red light, but now at trial, after you've had all this time to prep with the prosecution, you're now telling me the light was green? What changed between the preliminary hearing and now that you have changed completely your story? Could it be that you've been coached by the prosecution? See how that would really undermine Miss Smith's credibility. The defense often doesn't call witnesses. This is typical. I mean, it's early in the case. They do have all the discovery. They want to see how the prosecution presents their case before giving their hand because they don't have to disprove anything. They just have to make sure the prosecution doesn't reach the standard of probable cause, which is a pretty low standard when you come down to it. And the defense doesn't have to call witnesses, but they can. Ordinarily, the defense is just going to kind of wait and see, hold their cards close to the chest, and basically just watch what's going to happen because there's lots of theories of the stories that the prosecution can take, and it kind of behooves the defense to see which theory the prosecution tests and whether it falls on its face or it flies. And the advantage for the defense in not calling witnesses and keeping their strategy kind of mum is that they have the element of surprise. The prosecution doesn't have the element of surprise, but the defense can decide how they're going to spring their defense on the prosecution at trial.
And we have dealt with this before. Alice and I have dealt with this before in a different sort of circumstance. The courts we practice in didn't really have preliminary hearings. We were doing a lot of grand jury type stuff, but there were certain instances in which you would have a preliminary hearing before a final hearing. And there were times where the defense would come in and they would vigorously contest the preliminary hearing, and we would always win because the bar to preliminary hearing is so low. And I can remember talking to Alice about it and being like, I don't understand why they did that, because now we know exactly what they're going to say. When we get to the final hearing where the burden on us is higher, we know exactly what they're going to say, and that gives us some advantages. Number one, we can do more investigation. If they really weakened you in that preliminary hearing and really point out some holes, as we've said before, the investigation continues basically until the jury gets the case. You've still got people looking at stuff, thinking about stuff. If holes are popping up in your case, you're trying to fill them. Well, this is an advantage for the prosecution if the defense puts on a case. Ordinarily, the prosecution has no choice. They got to say something. And they've got to decide how much they want to say, because they certainly want to meet probable cause. They don't want to go much further than that, but they don't want to take any chances either. A huge advantage for the defense, because they hear them put on evidence, they hear their basic theory of the case, they hear them walk through the things they're going to say. Then the defense can spend the rest of the time getting ready for trial, thinking of how they're going to rebut that at trial. If, on the other hand, the defense starts putting on witnesses and doing a lot of cross-examination and all that stuff, they are signaling to the prosecution, this is going to be our defense. And the prosecution then has something they ordinarily don't have, which is a glimpse into the theory the defense is going to present. And at that point, they can start doing more investigation, trying to shore up those holes. So ordinarily, you're just not going to see a lot from the defense in these preliminary hearings. It's sometimes said that the defense can't put on witnesses. That's usually not true. There may be some states where that's true, but in a lot of cases it's not true. They can put on witnesses. They just choose not to. And it leads people to think they can't. They just choose not to. They let the prosecution sort of do its thing. They gather the information they're going to get from that, and then they move forward with it.
Another good strategy to that is, remember, the defense has seen the evidence and they probably know that probable cause is going to be met. So kind of it's a do no harm part of the case. You already know probable cause is likely going to be met. And so let's not, shoot yourself in the foot too early in the case, because the case is going to go longer than this hearing.
Right, exactly. It doesn't mean that they never do it, though. You can attempt to defeat probable cause, and you can imagine some circumstances in which you might want to do that. If you really have some good knockdown evidence, maybe you can end the trial there. And the evidence you're putting on, when you're the defense, and this is something that I think confuses people. People saw, and we're going to talk about this in a second, but they see exculpatory evidence and they lose their mind. They see it and they just think, oh my goodness, they're going to prove that Kohberger's innocent. What are we going to do? And it's like weeping and gnashing of teeth. The number of people who this story came out and we start getting emails and direct messages and tweets and Facebook and just everything with people panicked, wanting to know what's going on.
And that's so true, because the definition of exculpatory is it could be anything, right? We've seen cases, with defense counsel in court that say, well, this witness says that they saw a 5'7" man. My client is 5'7.5". It could not have been my client. And you're like, well, okay, technically, you're right. That's not completely consistent, but who can tell a half inch? And that doesn't really necessarily lead to the innocence of your client, but that is by definition potentially exculpatory evidence.
Exactly. Exculpatory evidence, it doesn't mean this piece of evidence proves you're innocent. All it means is it's evidence that tends to show that the person accused is not guilty. So Alice's example is a great one. That half inch, who knows? Maybe a juror would hear that and think, well, it is a half inch. That's something. It makes me doubt just a little bit. It's technically exculpatory. And you can imagine how this goes. Let's say you got like a shooting case and it's someone who shot somebody on a public street and there are a bunch of witnesses. And suppose that the person who gets arrested for doing it is a white male. And you have a witness who gets on the stand and they say they saw a white male firing a gun. That would be an example of inculpatory evidence. So inculpatory evidence is the opposite of exculpatory evidence. It's evidence that tends to prove the guilt of the accused. But then imagine the defense puts on another witness and they say, I saw a black female. pulling the trigger. That would be exculpatory. So now you have these two witnesses, one that seems to show that it is the accused, one that seems to show that it's not, and that's the way trials go. For the prosecution is putting on inculpatory evidence on cross-examination. The defense is trying to undermine that or maybe even introduce some exculpatory aspects of the testimony. If the defense calls witnesses, they're calling witnesses who are going to provide exculpatory evidence, and the prosecution on cross-examination is going to do the exact same thing. They're going to try and turn it into inculpatory evidence. We're going to keep using the Murdaugh trial because it's fresh and we talked about it so much. But remember, the defense, they put on a witness who was one of the law firm partners. And the whole purpose of that was for him to testify about how broken up Alex Murdaugh was the night of the murder and about how SLED led everybody in the world onto the scene. That's exculpatory evidence in two ways. Number one, it seems to say that his state of mind was not that of a killer. And number two, it undermines the other evidence of the prosecution because it says, look, they didn't maintain the scene. So who knows what could have happened there. Then on cross-examination, the prosecution gets up and they drag all this stuff out of this guy that's really bad for Alec Murdaugh about how he wasn't the person he thought he knew, how he could lie to you to your face and you'd never know it, how he betrayed everyone he ever loved, like all this stuff. That was all inculpatory from the same witness. And at the end of the day, it's up to the fact finder, in that case a jury, in the case of a preliminary hearing, the judge, to weigh that testimony and decide which one's weightier, which one do I believe more, which one do I think is more compelling? Which one's more relevant? In a preliminary hearing, it doesn't take much. All the prosecution has to show is probable cause, which is a reasonable ground to believe the charge is well-founded. Very minimal bar, and a bar that usually the prosecution is going to be able to meet without too much trouble. In this case, there was a bit of a curveball thrown. I mean, it wasn't much of a curveball, but it was a curveball that a lot of people really freaked out over when Bryan Kohberger decided to subpoena one of the surviving roommates to his hearing. Her name is Bethany Funk, and in the subpoena, he says that she may have exculpatory evidence.
So this is very interesting. Remember, either side can subpoena use the power of the court to call witnesses to the court. And a subpoena is just that. It's just a court order that you have to appear, because if people were given the choice whether to show up of their own volition to testify in a high media interest case, they're not going to want to come generally. Like I barely even show up to appointments that I want to go to. I'm certainly not going to go out of my way to take time off work to go testify in a hearing if I didn't have to. And that's why the court orders people to come through the power of a subpoena. And the reason Bryan is saying that he thinks Bethany has exculpatory evidence is because he has to show a reason to subpoena someone. You can't use the subpoena just to harass people. So you can imagine if there were no standard, you could literally sit there and just subpoena everyone that had to do with whoever's bringing the case against you, the victims' families, whatever, to try and use this harassing mechanism to get them to drop the case. That is not what the court's power is for. The court's power is to get testimony that is germane to the case, germane to the hearing that they are about to have, to help the court determine the truth of the matter, right? And that's why Bryan asserts that she has exculpatory evidence, because if he can't just say, I'm curious what she has to say, he has to have some sort of basis to believe that she will not waste the court's time and that he is not using the subpoena as a harassment tool. Now, it's really not hard to imagine what this exculpatory evidence would be, even though Kohberger's team didn't spell it out in the subpoena, and you don't have to spell it out in a subpoena. Funk probably either saw or heard something that the defense will argue could not have been Kohberger, or she saw or heard something at a time that doesn't really fit the prosecution's timeline, suggesting the killings happened well before or well after Kohberger would have been in the area. Again, if you read the probable cause affidavit, you know that Funk, or really the surviving roommates, heard things in the night when they didn't know it was significant. So it would make sense that they weren't on high alert. They weren't there taking notes on every single thing. So it would be very possible that your memory isn't going to perfectly fit whatever timeline is happening. When I wake up in the middle of the night, as I do all the time right now with my newborn, I don't know if it's 1 a.m. or 5 a.m. And that may very well have been the case here, but you can see how if the defense can kind of draw out some contradiction in the timeline or in what Bethany heard, they can show that, oh, there's no way our client is the murderer. Now, this is not surprising because if you receive a subpoena, you do have rights. It's not just a one-way ratchet. If you receive a subpoena, you always have the right to file a motion to quash the subpoena. And what that just means is you've asked the court, there's no reason, and you list out your reasons why I need to appear for this case. And it's not surprising that Bethany filed a motion to quash the subpoena in this case. I know a lot in the media are surprised by this, or people are tweeting, oh my goodness, there's been a big misstep, or what are they hiding? Because they can't seem to understand why the survivor of a brutal murder of 4 people would not want to be required to testify multiple times, with the first one for the benefit of their friend's murderer. Now, it would be highly unusual and probably disturbing to the prosecution if such a witness did not move to quash. In this motion to quash, the lawyers for Funk noted that before someone can be compelled to appear to testify, there must be a showing that their statements are material and necessary to the case for the reasons that I stated earlier. The defense subpoena claims without any support, without citations to anything, that Funk has exculpatory evidence, but it does not even hint at what that evidence is. Really, they're just using kind of like a buzzword. Sure, there's exculpatory evidence, but you can't just say it. You have to make a showing that it's likely she will have that sort of evidence. I want to say something real quick about quashing subpoenas and subpoenas in general. Subpoenas are very common. If there is a court case happening in general, civil or criminal, there's going to be a number of subpoenas issued in that case because, again, it is a court order to require a third party to do something. And you need that because third parties just don't really feel like doing something that has nothing to do with them. And also, motions to quash are very common. I mean, I would say, so those of you who've been listening to the show for a while know that I recently entered private practice. It is amazing the number of calls I get asking me questions about the subpoena process to quash them, whether they have to appear, what it means to get subpoenaed, what standards they are. It's because it's so common and most people don't understand how they work. And so when they see a court order or they hear subpoena, it kind of makes the hairs on their neck stand up and they get very scared. I had a client earlier who was like, oh my goodness, before I talked to you, I thought I was going to jail. And it was like a civil subpoena. They certainly were not going to jail. And they were like, custodians of some records that were on a civil matter that had nothing to do with a criminal case. But just the fact that they received a subpoena made this particular person so anxious they couldn't sleep because they thought they were going to jail because they got a subpoena. That is not the case. Just know how commonplace this tool is in the judiciary system.
And lawyers know very well that the average person, if they receive a subpoena, will freak out. They totally know that, and they use it to their advantage all the time because people are terrified of testifying. And that's just an ordinary person. Here, just to echo some things Alice said, can you imagine the trauma this person went through? This is one of the surviving roommates. Probably wonders why she's still alive. Probably helped find the bodies. She does not want to testify for this guy. And the number of people who are like, it's very troubling that she would fight testifying. What does she have to hide? It's like, what is wrong with you? Of course she doesn't want to testify. She's going to have to testify eventually if there's a trial. If there's never a trial, she won't have to testify, and good for her, right? But she certainly don't want to testify multiple times, and she doesn't want to be a tool for the guy she thinks killed her 4 friends. So she's going to fight it, and more power to her in fighting it. And that's the first thing. The second thing, if this goes to trial, the roommates are going to be a big focus because, as Alice said, they are not going to remember things. This was late at night. They had been drinking, and there was a traumatic event. That's like the trifecta. People are terrible about time. They're awful about time. They're awful about remembering exactly how things happened and when they happened. And when you add they're tired, it's even worse. Oh, and they also have been drinking? Even worse. Oh, and they have PTSD from finding their 4 roommates murdered? Even worse. So this will be part of the defense's attempt to prove that Kohberger is innocent. They will point to things they say that are inconsistent with the timeline established by the police based on phone pings and that kind of stuff. I mean, the police have a pretty good idea of when all this happened based on tracking Kohberger's phone and tracking the car and the cameras and everything else. So if one of the roommates told a police officer, I heard a noise at 5:30, And we know that Koberger was already back in Pullman, Washington by 5. Well, that's a piece of exculpatory evidence. You know, you want to put them on the stand and say, hey, didn't you tell the cops you were hearing things at 5:30? I did. That's exculpatory, right? Doesn't prove he's innocent. Probably just proves you got your time wrong. But it is something they'll want to put on, and you can imagine why. But spoiler alert, at the end of the day, we don't have to wonder about this because we now know just how unserious this subpoena was. Just today, the defense reached an agreement with Funk that they would quash the subpoena if she would sit down with them for a formal interview. In other words, they wanted to do a formal interview from the beginning. She said pound sand, and they used the subpoena as a bargaining chip. And that's exactly what happened. Defense attorneys are always wanting to talk to witnesses, and oftentimes witnesses do not want to talk to defense attorneys because they're pretty sure that their guy did it, and they don't want to help them. So this was an effective strategy by the defense. Go ahead and subpoena her, and then use that as your bargaining chip. And now they're going to get this interview. And it doesn't lock her in the same way a preliminary hearing would, but they're going to hear the information that they want to know, and they can use that later. If she testifies and she says some things to them in the interview that end up being inconsistent, they can use that. If she says anything that might be helpful, they obviously can investigate that further. So that was the point of this. Very typical. Nothing burger, as we said. And as we warned you last time when we talked about Giglio, this is going to continue to happen. There are going to continue to be filings like this that are standard operating procedure or they're strategic actions, tactical moves that don't really mean anything, but lots of people are going to try and get you really revved up about it and believing that there's something going on here. We'll use those as opportunities to talk about these kind of things because it's a nice hook to talk about things like subpoenas and preliminary hearings. So we'll continue to do that. But I don't want you guys out there to worry that the whole case is falling apart because somebody did something that you do in every case.
So basically, to sum up this episode, in conclusion, despite all of the headlines you're seeing about the Idaho murders case, everything is going as expected in a case like this. This is a nothing burger. Everything is progressing as a case like this should be, with attorneys joining as they should be in a large case, with preliminary hearings getting revved up, and witnesses being subpoenaed, and witnesses not wanting to come and filing motions to quash, and settlements being reached in terms of quashing subpoenas. All completely normal, and nothing about these quote unquote developments, I would call them non-developments, I would just call them the life of a case, concern me at all about the prosecution's readiness for this case or the defense's ability to defend it vigorously in a way that is everything that Koberger is entitled to. So with all of that, Brett, do you have anything else to add?
Just that you nailed it, Alice. That's exactly right. We could have done a much shorter episode. Could have been like 30 seconds. As always, Alice, wrapping it up.
But then, boy, would people be angry. They're like, we wanted a 30-minute. You owed us a 30-minute episode. And, well, here you go. Here's your 30-minute episode. And we love you guys. We'll talk all day long. And I will talk all day long to you, Brett. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. No, we have to record all this because
Okay.
I know everyone complains about my sound. But two things. I have Taylor Swift's microphone, took it from a tour. And second,
You did.
now there's no longer a baby between me and my microphone, which makes a huge difference. But it's not really
Makes a
Taylor
huge
Swift's
difference.
microphone, guys.
It's totally Taylor Swift's microphone.
But it is Taylor Swift's microphone.
And we'll see how it sounds.
That was a little disingenuous. I'm just
We'll do
kidding.
our best.
You're like, let's get your sound right, man. This is the only thing that's holding us back from stardom is your dang sound, Alice.